So you've been in a car accident, your back is killing you. The MRI came back and the doctor is throwing around terms like herniated disc and nerve compression. And now you're wondering, how much is this case actually worth? Maybe the insurance company has already called you with a number, and then something in your gut is telling you that that number is too low. You're probably right. In this video, I'm going to give you a straight answer. We're going to talk about what lower back injury settlements actually look like in California in 2026, the ranges, the factors that drive value up or down, and the tactics insurance companies use to pay you less than you deserve. My name is Steve Sweat. I'm a personal injury attorney here in Los Angeles, and I've been in practice for over 30 years, representing car accident victims throughout California. I've handled hundreds of back injury cases, and I can tell you that the difference between a good settlement and a bad one almost always comes down to what you know and when you act. So let's start with the question everyone asks first. What are the numbers? I'm going to give you real ranges, but I want you to understand up front that every case is different. These are based on patterns I've seen over 30 years in practice in California. They're not guarantees. Your specific outcome depends on a lot of factors, and we'll get into that in a minute. So let's start with the first category, which is kind of the minor soft tissue injuries range. If you've been diagnosed with a lumbar strain or sprain, meaning the muscles or ligaments in your low back were stretched or torn, and you treated conservatively and recovered within a few months, you're generally looking at settlements in the range of maybe 10 to 50,000, could be less or more. These cases are real, the pain is real, but they're also the ones insurance companies fight the hardest. Because without showing imaging, which shows structural damage, they love to call it, quote, soft tissue and dismiss it as minor. We'll talk about how they do that in a minute and what you can do about it. Let's go to the next category, which is the bulging disc. A bulging disc is a step up from a sprain. The disc that cushions between the vertebrae is pushing outward, but hasn't fully ruptured. Your MRI shows a bulging disc and you treat it with physical therapy or maybe injections. You're typically in the $31,000 to $100,000 range. The MRI matters enormously here. Objectively, what does the evidence show? That kind of triggers the negotiation. Let's talk about a herniated disc. The spine diagram will show that a herniated disc, sometimes called a slipped disc, is where the soft inner material of the disc pushes through its outer casing and presses on a nearby nerve. This can cause radiating pain down your leg, numbness, tingling, weakness. It's confirmed on an MRI. Without surgery, these cases typically settle between 75 and 300,000, but that range moves a lot based upon the treatment, how long symptoms lasted, and how much it affected your life and your work. Let's talk about a herniated disc requiring surgery. If your herniated disc required a discectomy, that's where a surgeon removes the herniated material, or worse, a spinal fusion, the value of your case increases dramatically. Surgery means higher medical bills, longer recovery, more lost time from work, and more documented suffering. These cases routinely settle in the $200,000 to $750,000 range, and in cases with long-term complications, they can go higher. Let's talk about the next category, severe spinal damage. So at the top end are cases involving serious spinal cord injury, partial or complete paralysis, permanent nerve damage, loss of function. These are catastrophic cases and they fall into a completely different category. Seven-figure settlements and verdicts are common in these cases, though they also involve more complex litigation. So that's the landscape. Now let's talk about what actually moves the needle. Here's something important to understand. Two people can have the same type of back injury and end up with wildly different settlements. Why? Because some of these 6 factors are involved. Factor 1, injury severity and the objective evidence. The more serious the injury and the more it's confirmed by objective evidence, like an MRI or CT scan and nerve conduction studies, the higher the value. An insurance company can argue against your pain. They can't usually argue against a clear MRI showing a herniated disc at L4, L5 with nerve compression. This is one of the most significant things that you can do for your case. Get the imaging done. Don't let a doctor dismiss you with just a physical exam if you have ongoing pain. Factor 2, your medical treatment. The type and duration of your medical care directly signals to the insurance company how serious your injury is. Chiropractic care for 6 weeks is worth less than physical therapy for 6 months. Epidural steroid injections are worth more than either. Surgery changes the entire conversation. Your medical bills are the economic backbone of your claim. They establish a concrete foundation and they tell the story of your suffering. Factor 3, liability. Who's at fault? California follows what's called pure comparative negligence. That means your recovery is reduced by whatever percentage of fault is assigned to you. If the jury finds you were 20% at fault, you recover 80% of your damages. A rear-end collision where you were stopped at a red light, very clear liability. A multi-car highway accident with disputed facts, much more complicated. Clear liability cases settle for more and faster. Factor 4, insurance policy limits. Here's the hard truth. Even the most serious case is limited by available insurance. California's minimum liability coverage is just $30,000 per person, and that doesn't go far for a herniated disc case. A good attorney investigates all available coverage, the at-fault driver's policy, any commercial coverage if a commercial vehicle was involved, and your own underinsured motorist coverage. That last one is critical and massively underused. Factor 5, pre-existing conditions. This is where a lot of people get scared. They had some back problems before, maybe degenerative disc disease, maybe a prior injury, and they think that means they have no case. That's not true. Under California's eggshell plaintiff rule, the at-fault party takes you as you are. If the accident aggravated or accelerated a pre-existing condition, you are entitled to compensation for that aggravation. The key is having an attorney who knows how to document and present the distinction properly. Factor 6, lost wages and earning capacity. If your back injury kept you out of work even for a few weeks, that lost income is compensable. If it permanently limits your ability to do your job or earn at the same level, that lost earning capacity can be enormous. We use economic experts to quantify this in the most serious injury cases. So let's talk about the types of lower back injuries. Let me take a few minutes to explain the injuries themselves because understanding what's happening in your body helps you understand why some cases are worth more than others. Lumbar strains and sprains are the most common lower back injuries after a car accident. A sprain is a torn ligament. A strain is a torn muscle or tendon. Real pain, real limitations, but often dismissed by insurance companies as, quote, just soft tissue. Don't accept that framing. Bulging or herniated disc. Your spine has cushions between each vertebrae called intervertebral disc. A bulging disc protrudes outward. A herniated disc goes further. The inner material actually ruptures through the outer layer. When either one presses on a nerve root, you get what's called radiculopathy. That's shooting pain, numbness, or tingling down your leg that many people call sciatica. These are objective and diagnosable injuries. Get the MRI. Nerve damage and radiculopathy, chronic nerve compression, can cause permanent damage. If the nerve is irritated long enough, you can develop lasting numbness, weakness, or chronic pain. Even after the disc issue is resolved, nerve conduction studies can document this objectively and significantly increase the value of your claim. Spinal cord injuries, the most severe category. When the spinal cord itself is damaged, not just the nerve root, but the cord, the consequences can include partial or complete paralysis. These are catastrophic injuries requiring lifetime care, and the damages in these cases reflect that reality. One of the most important things I tell every client is this: your medical treatment is not just about getting better. It also builds your case. Let me walk you through what the treatment ladder typically looks like and what it means for your settlement. Chiropractic care, typically $3,000 to $15,000, often the starting point for soft tissue injuries. Legitimate and useful, but by itself, limited settlement impact. Physical therapy, $5,000 to $25,000, let's say. More medically recognized than chiropractic and insurance negotiations. Builds documented evidence of ongoing injury and effort to recover. MRI and diagnostic imaging, $1,500 to $5,000. Non-negotiable for serious claims. Without imaging, the insurance company will call your injury subjective. With imaging, it's objective, documented and real. Epidural steroid injections, $5,000 to $25,000 per injection usually. When conservative treatment isn't working, injections signal a more serious injury and substantially increase the case value. Discectomy surgery, $15,000 to $100,000 or more. A surgical recommendation from a neurosurgeon or orthopedic spine surgeon changes the entire trajectory of your case. Spinal fusion, $100,000 to $300,000 usually or more. The most serious surgical intervention and a significant driver of seven-figure case values. Here's the key takeaway. Follow your treatment plan. Don't skip appointments. Don't stop treatment early because you're feeling a bit better or because you're busy. Gaps in treatment are one of the main arguments insurance companies use to minimize claims. And never, ever settle your case before you've reached what's called maximum medical improvement. That's the point where your condition is stabilized and your doctors can tell you what your long-term prognosis is. If you settle before that, you may be signing away your right to compensation for future treatment when you don't even know what you'll need. A lot of people focus entirely on their medical bills when thinking about what their case is worth. But in California, you're also entitled to compensation for pain and suffering, what the law calls non-economic damages. This covers the physical pain, the emotional distress, the sleepless nights, the things you can't do anymore. Coaching your kid's Little League team, going to the gym, doing your job without pain. These losses are real and California law recognizes that. Unlike some states, California does not cap non-economic damages in personal injury cases. That means in serious cases, pain and suffering can actually exceed your medical bills. So how is it calculated? Well, in California, there's no fixed formula. In practice, attorneys and insurance companies typically use one of two approaches. One would be the multiplier method. You take your total economic damages, medical bills plus lost wages, and multiply it by a number between 1.5 to usually 5, depending on how serious and how lasting the injury was. A minor soft tissue case might be the 1.5. A serious herniated disc requiring surgery might be 3 or 4 times. The second method is the per diem method. You assign a daily dollar amount for each day you suffered, say $200,000 a day, and multiply the number of days from the accident until you reach a maximum recovery. If that's 365 days, that's over $75,000 in pain and suffering alone. Let me make this real with some hypothetical examples. I want to be clear, these are illustrative scenarios, not guarantees, but they reflect the kinds of outcomes we commonly see in California cases. Scenario 1, a rear end at a stoplight with a lumbar strain. 35-year-old teacher rear-ended at a red light. 10 weeks of chiropractic care, no imaging showing structural damage. Full recovery, clear liability. Medical bills around $8,500. $2,000 in lost wages. After a 1.5 pain and suffering multiplier, this case likely settles in the $22,000 to $30,000 range. Scenario 2, T-bone collision with a herniated L4, L5, but no surgery. 48-year-old contractor struck at an intersection. MRI confirms a herniated disc at L4, L5, 3 epidural injections, physical therapy, 6 weeks out of work. Medical bills $42,000 and lost wages $18,000. Pain and suffering at a 3 times multiplier adds up. This case is in probably the $100,000 to $200,000 range. Scenario 3, a freeway crash with disc injury. 55-year-old nurse gets hit by a speeding driver on the 405. Spinal fusion surgery at L5, S1. She can no longer perform nursing duties full-time. Permanent limitations. Medical bills $185,000. Lost earning capacity over $200,000. Pain and suffering at 4 times, and you can quickly see how this becomes a 7-figure case. Subject to available policy limits, this is a $750,000 to maybe $1.5 million case. Scenario 4, we've got a 64-year-old with prior degenerative disc disease, gets rear-ended. The accident aggravates his L3, L4, requiring injections and 5 months of treatment. The insurer fights hard, pointing to prior imaging. But under California law, the defendant is still responsible for the aggravation. With strong medical documentation, this case settles in the $55,000 to $85,000 range probably, reduced somewhat for the pre-existing condition, but far from zero. The moral of these stories, the range is huge, and where you land depends almost entirely on the quality of your medical documentation and the quality of your legal representation. This might be the most important part of this video, so stay with me. Insurance companies are not on your side. Their adjusters are trained and incentivized to minimize what they pay out. When it comes to lower back injuries, they have a specific playbook, and if you don't know what's in it, you're at a serious disadvantage. Tactic number 1, it's just soft tissue. The phrase soft tissue is used like a weapon. They'll say your injury is minor, subjective, and probably unrelated to the accident. The antidote, objective imaging. An MRI that shows a herniated disc is not soft tissue. Don't let them frame your injury for you. Tactic 2, blaming pre-existing conditions. They'll get a full copy of your medical history and go looking for any prior back complaints. Even a mention of back stiffness 5 years ago becomes, quote, evidence that your current injury is pre-existing. Your attorney knows how to counter this with the right medical experts and documentation. Tactic number 3, the early lowball offer. They may contact you within days of the accident, before you even fully know the extent of your injuries, with a settlement offer. It's designed to take advantage of your financial stress and your uncertainty. Once you sign, it's over. Never accept any offer before reaching maximum medical improvement and consulting an attorney. Tactic number 4, the recorded statement. An adjuster calls, sounds friendly, and asks if they can just get a quick statement about the accident. What they're actually doing is creating a record they can use against you. You are not required to give a recorded statement to the other driver's insurance company. Politely decline and call an attorney first. Tactic number 5, surveillance in higher value cases. Insurers sometimes hire private investigators to photograph or film you doing activities that appear inconsistent with your injury claims. Be aware of this and be honest. If you're having a good day and you're out walking, that doesn't mean you're not injured. But exaggerating your limitations will destroy your credibility. Knowing these tactics is your first line of defense. Having a good attorney is your second. Let me quickly cover the legal framework you need to understand before making any decisions about your case. California's 2-year statute of limitations. You have 2 years from the date of the accident to file a personal injury lawsuit in California. If you miss that deadline, you're going to lose your right to compensation, period. There are limited exceptions. For government vehicles, the deadline is even shorter, just 6 months to file an initial claim. So don't rely on exceptions, act now. Pure comparative negligence. California law allows you to recover even if you were partially at fault. If you were 30% responsible for the accident, you recover 70% of your damages. So don't let an insurance company tell you that because you were partially at fault, you have no claim. That's simply not true under California law. Let's talk about the typical case timeline. Here's how a typical lower back case moves. In the first few weeks, you're focused on medical care and gathering evidence. Months 1 through 6, you're treating actively. Once you reach maximum medical improvement, MMI, your attorney puts together a demand package with all your medical records, bills, wage loss documentation, etc. Negotiation typically takes 1 to 3 months after that. Most cases settle without going to court. If the insurer refuses a fair offer, we file a lawsuit. Trial cases can take 1 to 3 years total from the date of the accident. In simple soft tissue cases, 3 to 6 months is usually the typical time frame. Surgical cases, 12 to 24 months or more. The key message, you gotta be patient and don't let financial pressure put you into a premature settlement. So before I close, let me give you the 6 most important things you can do right now to protect your claim and maximize your settlement. Number 1, seek medical care immediately and consistently. Gaps in treatment are the number 1 way people hurt their own cases. 2, get the imaging done. Don't let a doctor dismiss you with just a physical exam. Insist on an MRI if you have an ongoing pain. Objective evidence is everything. 3, document everything. Photos of your injuries, the damage to both vehicles, the accident scene. Keep a pain journal. Save every medical bill and record. 4, do not give a recorded statement to the other driver's insurance company. Politely decline, call an attorney. 5, stay off of social media. Don't post about the accident or your activities. Insurance companies monitor social media and will use your posts against you. 6, hire an experienced personal injury attorney. Studies consistently show that represented claimants recover significantly more than those who go it alone, even after legal fees. We work on a contingency, meaning you pay nothing unless we win. There's absolutely no reason not to at least get a free consultation. On that last point, let me be direct. If your injury is anything more than a minor strain that healed completely in a few weeks, you should talk to a lawyer. Not because I'm trying to get your business, but because the insurance company on the other side has a team of professionals working to minimize what you receive. You deserve to have someone in your corner. So let's bring it all together. Lower back injury settlements in California range from $10,000, sometimes less, for minor soft tissue cases, all the way up to $2 million, sometimes a lot more for severe spinal injuries. Where your case lands depends on your injury, your treatment, the evidence, the insurance coverage, and how well your case is presented. The insurance company is already working against you. The best thing you can do is to get informed, which you've just done, and get representation from someone who has been doing this for a long time and knows how to fight for what you deserve. So if you've been injured in a California car accident and you want to talk about your case, my firm offers completely free consultations, no obligation, no pressure. Just an honest conversation about your situation and your options. You can call us at 866-966-5240. That number is in the description below. Or go to victimslawyer.com to submit information and we'll reach out to you. We're available 24 hours a day, 7 days a week, and we serve clients throughout Los Angeles and all of California. And if you found this video helpful, please hit the like button, subscribe to the channel, and share this with anyone you know who's dealing with a back injury after a car accident. There's a link in the description to the full written guide we put together on this topic, which goes into even more detail. I'm Stephen Sweat. We've been fighting for accident victims in California for over 25 years, and we'd be honored to fight for you. So thanks for watching.